appearing.
No, I am not allowed.
Ma-
Yesterday,
Ah,
one matter.
Can you
Lordship,
please send for Mr. Taposh Bhattacharya and Miss Koeli Bhattacharya?
I will.
My lord, I am mentioning a matter
All
for
mentioning on
urgent need of correction.
Monday.
My lord, this is correction.
On Monday, no mention.
Lordship,
All on Monday. To be mentioned now, yeah, application under exam. This will have Yes, call the list.
Lordship, kindly grant me leave to file.
Not today, all Monday.
File the appeal without certificate
We'll
copy.
see on Monday. Yes, call the list.
My lord, it's urgent, my lord, in that
All
sense.
Monday, mention on Monday. Yes, call the list.
For orders. Item number 1. Item number 1, my lord. I have the state.
I am for the, Lordship, I am
I
for
for
the
the
district
appellate.
primary school council, Lordship.
My lord, kindly look to my lord. The order impugned is at page, my lord, 88 of the stay application.
আমাদের এপ্রিল মে মাসে কি সাসপেনশন টাকা
এগুলো রাখো।
Yes, subsistence allowance paid or who is that?
But here, Lordship, I am for the district primary council, Lordship.
My lord, no charge sheet has been given.
But
The-
here,
in
Lordship,
the month of July 20.
No, we are only a limited question. You said subsistence allowance was. not
Lordship,
paid.
here, Lordship,
Limited,
up to May, thereafter he terminate from the service, Lordship.
Without serving
Lordship,
the charge
no,
sheet, without initiation proceedings.
No, that is a
All-
different issue. You can
No.
challenge it in a.
I filed the writ petition challenging the order of suspension on the ground, my lord, July 2021. Since July 2021, no steps have been taken by the authority.
Lordship,
No
here,
charge
Lordship,
sheet, nothing has been supplied to me.
Yes, already served, Lordship. Here, Lordship, terminated letter, Lordship.
Termination letter, charge sheet has not been
Yes,
submitted.
all total has been sub. Kindly see the year.
Employee.
To challenge it. You
Challenge it,
in a
Lordship.
properly
That is
constituted
proceeding
proceeding.
there, Lordship.
Challenge it. Stay down.
But let a copy of the termination order be served.
Yes, here and now I am, sir. No, no, তুমি দিয়ে দাও, সব করে দেবো।
No, we want to know whether he has been paid all the subsistence allowance
Lordship, up to, Lordship, April, up to May, April 2023, Lordship.
up to April 2023.
2023, Lordship.
And he was terminated from service.
First June,
13th July
First June.
2021.
terminate
13th July 2021.
first June.
Suspension. Suspension
here,
order
Lordship.
passed. Suspension order passed on 13th July 2021.
So you'll be entitled from that date
That day.
till
Till the
termination.
date of termination.
What is the date of termination?
First June 2023, May.
So you have to pay him till
Lordship, kindly see.
30th May.
Lordship, I am paid,
30th May.
Lordship, April 2023.
30th May you have to.
Lordship, I am one month I am giving you, Lordship. Only 1 month I am giving. 2023, Lordship. You received the account, Lordship.
No.
Dekhen.
Month of May you have paid.
Lordship, no, all Lordship 26, 4.
Well, let a
15,
copy
3.
of the calculation be
yes.
supplied to me, my lord.
This is not where you have,
The
Yes,
bank
yes.
account, Lordship.
he was paid up to which date?
Which date, Lordship? Here, Lordship, April 2023.
No.
Up to, Lordship,
Oh, actually, April 2023.
23, Lordship.
So
Only
May you have not paid.
May, only month of May.
Stay down.
It only, দেবো?
The report filed by the
Doubt,
chairman. For the month of April 2023, in that month itself, he has received it on 17th of August. How it is possible?
7th of August, Lordship.
Yes, payment done on 17th of August.
Lordship,
Sure.
Lordship,
Yes,
DPC approved on 20.
it's
August
dependent upon
2020.
approval. It's
Lordship,
dependent upon approval.
Lordship, here, Lordship, money has been sent to the.
We are not on that. Is it dependent upon approval? Your officer will approve it after 3 months. Office,
Due to,
we are not concerned with this. This is not in terms with the rules.
but due to,
The
Lordship,
chairman has to pay from his own pocket.
but due to, Lordship, he,
No, there is no due to.
one,
There is no due to. Chairman has to pay from his own pocket.
May,
Let a copy of the
May.
statement
Not
be
only
given
May.
to me, my lord, for
You see that-
instruction.
Just a minute.
Lordship, is the account,
Yes.
Lordship, I am, Lordship, directed
Yes,
to
yes.
responsibility
Just a
person
minute.
is there. Lordship,
He filed an application on 26th April.
but the responsible person is here, Lordship, we kind of.
Yes, 26th April, and he released it on 17th of August.
বলুন
26/4/23 বিল টেস্ট করেছেন SIS party.
Was he required to file an application for subsistence allowance?
তা শুনুন অ্যালাউন্স জন্য কোনো বিল ফিল পাঠাতে হয়
হ্যাঁ, বিল পাঠাতে।
লর্ডস
SI অফিস থেকে SIS বিল করে পাঠান।
অ্যাপ্লিকেশন করতে হয়,
হ্যাঁ,
অ্যাপ্লিকেশন করতে হয়। 26 অ্যাপ্লিকেশন করেছে, আপনি 17ই অগস্ট ছেড়েছেন টাকা।
এবার ওটা হচ্ছে 28/4
আমরা ব্যাপারটা নিয়ে সে যখন অ্যাপ্লিকেশন করেছে সেই মাসেরটা তো তার ইমিডিয়েটলি তার পাওয়ার কথা, আপনি 3 মাস ধরে ফেলে রেখে দেবেন।
That lordship
Well,
due to the 2 month or 3 month
The
lordship.
applicant-
Why? What? Under what provision?
My lord,
There is no provision at all.
Then I will penalize the chairman for this.
But lordship here lordship 2 months.
No, there is no chair, no mercy.
করে থাকে কি?
proceeding.
my my
But that
instruction,
proceeding is going on there, so lordship.
There is no rule. Please don't
No,
support.
lordship, I am not supporting lordship, I am not
Please don't
supporting.
make us
I am not supporting, well, lord, here 2 month or 3 month is a delay.
Chairman has to pay from his own pocket,
Delay is there.
interest.
my lord, my instruction is that appellant present, my lord, in the court, my lord. Since March, my lord, no payment has been made. Subsequently, last week, my lord, only 25,000 without any accounts, that has been deposited in the account of the petitioner.
But here lordship, the bank challan is here lordship. Yeah,
Yes,
bank
yes.
challan is here lordship. If the lord delay is there lordship, I am giving lord.
দেখো 15 মার্চ দিয়েছে, pay from his own pocket, take down.
2 month.
We are, no, every month for this 9 months, is a fun going on.
11, 1, 3, 3, let's say here, let's say 3, 3 only for the, let's say that's the, let's
So
say.
we'll direct, whatever we direct, yes.
And kindly see the application for PF disbursement.
PF is the bound to due to the pay.
মানে এটা তো দিতে হবে তো।
The statement filed
fit for the post. That says the honorable single judge. But what has happened, my lord, without any, my lord, issuance of charge sheet, without any opportunity of, the kindly see the termination. May I read that?
They said charge sheet was issued. We don't know the reason. Charge sheet has been issued. They are saying.
But I am not
Bolla.
getting the copy.
Challenge. একটা জিনিস করবে we make it clear that March 2021.
13 March 2021. Kindly see, my lord.
দেখি দেখি 13 মাস কোথায়?
Later, my lord, is at, my lord, page 59. Kindly see page 59 once.
It's an act of insubordination.
But what has happened, my
But
lord?
Lordship,
It's an
here,
act of insubordination.
I am Samli, but
It's an act of insubordination.
My lord, what has happened, my lord?
Can
Earlier, my
the
lord,
head teacher write it to the chairman in charge?
I am
this
not
kind of
bothered.
letter,
kindly
this
see,
kind
my
of
lord, the
letter?
background fact of issuance of the
Whatever
letter,
the
my lord.
background, can he write this kind of letter to the chairman? It's an act of insubordination.
My lord, because, my lord, 11 teachers of the school, my
Doesn't
lord.
matter. It's an act of insubordination on the face of it.
My lord,
But one Lordship,
my
here,
lord, one
some allegation,
subsection, my
Lordship,
lord, 11 teacher, my lord, of the-
one pregnant teacher, Lordship, transfer from the one post to another, but he refused to join their Lordship.
join there because, my lord,
Is the Lordship
because, my lord,
pregnant lady, Lordship?
He cannot write this kind of letter to his superior. It's an act of
my
insubordination.
lord, that I understand.
Then how can you support this letter?
No, kindly see, my lord, the letter dated 27th February 2020, 2021, which is at
You may-
page.
That is a different issue.
No, no,
But
no.
this is other way, and if you are aggrieved, you should have challenged it some forum.
That is not the other issue, my lord.
No,
What has
this-
happened?
this
11
letter-
teachers did.
This letter is an act of insubordination on the face of it.
That's why the honorable single judge, judge, my lord, said that, my lord, she is not fit for the.
Yes,
But one thing is this. One thing is this.
but here, Lordship, two teacher, Lordship.
Just a minute, please
Lots.
allow us to finish.
Yes, yes.
On this basis, no disciplinary proceeding was initiated.
Lordship,
On
yes, inquiry of, Lordship, I am telling you, but my
the
learned
basis of this letter,
inquiry officer has been appointed.
on the basis of this letter or on the basis of the order of Justice Gangopadhyay?
Lordship Gangopadhyay, basis of this letter, Lordship, not the Justice Gangopadhyay.
Initiation was,
Lordship, that order has been
Initiation was-
passed
no, initiation was made prior to,
prior.
not on the basis of.
No, prior to, Lordship. I am submit, let them, my submission has been recorded, Lordship.
May I read that order of termination? once?
Mr. Vaishya has submitted that.
compliance with the order dated 18th May 2023, the Honorable Justice Obhijit Gangopadhyay,
Discipline has been completed.
which states,
Lordship directed,
I am of
discipline
the
has been
opinion,
completed.
I am of the opinion that teacher is
Discipline has
not
been
fit for the
completed.
post.
Yes. Discipline
In
has been
compliance with
completed.
the order, in compliance with the order passed by the Honorable Single Judge, I declare that she is not fit for the post.
Yes.
Then
There the
the-
discipline,
You need to revisit this because of our observation here.
but disciplinary proceedings has been
Maybe, but
completed.
this is what he has ordered, this challenge this order.
Lordship.
Now, during the pendency of this order, you have terminated him.
Lordship,
We are-
that's a,
Yes.
no, no lordship.
In the
That-
order, my lordship, kindly
Lordship,
gone
kindly
through the
see
order,
the
the
order.
second portion, I am of the opinion that the so and so,
Yes.
I am told that the disciplinary proceedings
order
against
taken,
the petitioner has been completed by the DPSC. The result of the disciplinary proceedings is to
Communicate.
be intimated to the appropriate authority
Only order.
and to the petitioner within 2 weeks. This is the, my
Only
lord,
intimate,
the order.
nothing to anything.
and compliance has
Only
been made,
intimate.
compliance has been made.
Yes, only intimate.
This is kind of letter ought not to have been issued.
Lots of
prove-
fact is that, my lord, 11
What's the
teachers, my
background?
lord,
You see,
they were
what
not
happening, what is happening now, that act of insubordination is in there on the rise. And if a head teacher writes this kind of letter to
Then it
his
happened.
superior, this is not in good taste. Whatever may be the cause of agony, we are either losing control on our language and expression because of lack of knowledge or ability to write. This communication can be made in a different language, communicating the same feeling.
Yes, yes.
But this letter on the face of it is an act of insubordination.
Well, on the date of incident, my lord, chairman with the, my lord, local
Very well.
political
There, no
members, my
political.
lord,
Why are said
went
mentioned
to
in the
the,
political?
went
Why
to
you
the
are
school.
mentioning the
No, 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 no.
Political, why
Went
are
to
mentioned in the
the-
political? Reason why I am
11
not
teachers
talking-
of the school were not
That was
finding the
earlier.
registered since 2013.
Sir,
The
what can I
petition
say?
is pending before this honorable court. And there is a direction, my lord, for to sign upon them, my lord, to sign immediately, to sign the registered. Even then, my lord, no, nothing has been, no steps has been taken. That's why the headmistress, my lord, said that, my lord, I placed the, all the
We can do
records.
one thing, whatever subject to what you say, we can, because that is based on the order of Justice Gangopadhyay, we can say that the disciplinary authority shall revisit the issue on the basis of the observation made in this order. That's all, because you said in compliance of the order of Justice Gangopadhyay, since we are diluting the order,
Yes, yes, yes.
But lordship,
The order of
lordship,
termination is, sir,
communicate, discipline,
No,
complete
the
and
only thing
communicate.
what I
nothing has been completed.
Com- Yes,
only
yes.
things we are in just a minute, compliance with the order dated so and so, Honorable Justice so and so, which states so and so. And as per report of the disciplinary proceedings, the charges framed against Timothy so and
No, no,
so
no.
has been proved by the evidence recorded by the inquiry officer. Thus, the undersigned has to remove her from. So, my lord, this is only quoted. This is not the findings, because this his lordship
Finding is the report,
has
lordship, committee
directed
report.
to communicate within 2 weeks.
no, difficulty is this, his lordship has said she's not fit for the post of
But
teacher.
here, my lord,
But
here, my lord,
That is,
that
that
has-
observation.
Lordship, inquiry officer, I am.
Can you- can you-
Subsequently,
Chairman,
report.
no, no.
Can the chairman take a different point?
No, no. Here only.
So it was still,
Lordship, kindly see that
Yes, yes, yes.
inquiry
No,
officer,
that-
inquiry officer, what are saying? Inquiry officer report. Hereby.
we'll do one thing, we'll do one thing, you revisit the order of the punishment
Yes,
after
yes.
giving her an opportunity of
Yes,
hearing,
ma'am.
and she should not be
Well,
based on the
look,
observation.
we trace to the trial. No, Lordship, we are,
Dispose
Lordship,
of this
that, Lordship, you did not challenge it in the trial court, Lordship, only for the challenge in the
My
disciplinary proceeding.
petition based on,
No, I am giving the submission,
No, no,
Lordship.
the writ petition is challenging the order of Justice Gangopadhyay.
Lordship,
So if
but
any
Lordship,
action
after
is,
it terminated,
action is taken,
Lordship,
no, no,
Lordship,
if action is taken based on that, then then
Lordship, I am coming, Lordship. If the Lordship, any
I am
grievance,
saying
Lordship, challenge,
that portion will operate as a res judicata.
don't get you cut, Lordship, here.
Since
What is the-
Let-
what is
let-
the
let-
final
let-
order of
let-
termination?
let- say, Lordship.
What is the final order of termination? Sure.
Final order I am giving you, Lordship. Yes.
Order of termination.
Order কোথায়?
What is the final order of
only see
termination?
the first
Yes.
3 lines.
No, no,
What
no.
is
Final order of termination.
Final orderটা দাও না
This is the,
that, Lordship, report has been filed, Lordship?
এটা তো পিটিশনের
it is
No,
report.
report,
the
inquiry report, like that inquiry.
না, না,
inquiry-
তুমি final order of termination টা বলুন না।
এই তো final order of termination.
The first page.
Final order of termination is here. He is a challenge in the termination. I am giving you lots of termination order, Lordship.
একটা কাজ করো, in the event a writ petition is filed challenging the order of termination, একটা কাজ করো তো, শোনো শোনো। House in a you may not get the pension. So for that purpose, you have to conclude the disciplinary proceeding.
Then why not, I could not, I submit it not say, I submit the judgment, our High Court division made judgment. Judgment 1998, Boytona Mukherjee.
Yes.
Similar fact, that was in the that appeal. But Rule 28 sub-rule 2 does not say, has not given any power to the full authority to.
May not be the school. That is why we have also asked
Sir,
Ms. Quelly, because you see, what would be the situation? Because even if we say no, you will not get your pension.
I shall press that judgment.
No, irrespective of the judgment, we have to see the rules. Judgment will come later. Judgment, don't show us the judgment first. Let us first see the statute.
The statute is that.
You see that 28.8 is no more there available. Now board is there.
What is there?
So board can conclude this proceeding within a certain time, because otherwise you will not get the pension. You will have no victory at all.
I shall come.
Come at 2 p.m. Come at 2 p.m. Inform Ms. Koili Bhattacharya also.
I reach my chamber, in my residence, so I shall press that judgment, but consult that judgment.
Please
That
come
we
at
have
2
been-
p.m. Please come at 2 p.m. with Ms. Koili Bhattacharya.
That
We want to know from you.
specifically stated that everything has been discussed. That what's foreign from your losses, that has been asked before the land, division bench also. The division bench.
Please come at 2. Please come at 2.
Yes.
Yes, item number 2.
Well, I'm for the appellants in this matter, my lord.
For the petitioner respondent,
Yes, yes.
Well,
yesterday report was filed by the district primary school council. And I have gone through the report, my lord. In the report, it has been stated that, my lord, I am not entitled for the compassionate appointment because my father was not a primary school teacher, my lord. My father was a teacher of a high school. My lord, it has been contended in the report that rule 2M of the concerned rules, my lord, defines the term teacher, where teacher is a primary school teacher.
Yes, yes, yes.
Primary school teacher. Now, my lord, I shall rely upon a 1987 government order, but where it has been said, if a ward of a teacher of a high school, my lord, is entitled for.
Where is the report? Where is the report? Report.
এই রিপোর্টটা কালকে দেওয়া দিয়েছিল?
Yes, yes, yes.
It has been said that since my father was a high school teacher, not primary school teacher, so I am being the ward mart, I am not entitled for compassionate appointment under district primary school council.
Correct.
And the rule 2M has been quoted there, where my definition of teacher is there, primary school council. Primary teacher means primary teacher. Now, my lord, I shall rely upon a 1987 government order where it has been said, my lord, if a teacher of a high school dies prematurely and his ward does not have sufficient qualification for appointment of teacher in high school, then, my lord, district inspector of school secondary education shall forward my name to the district primary school council for appointment of teacher of a primary school. So under this provision, my lord, the district inspector of school secondary education, my lord, forwarded my name to the district primary school council. May I place the government order, my lord? Government order number 557 dated 12th of October 1987. And issued by the Deputy Secretary to the Government of West Bengal to the Director of School Education. And kindly see, my lord, paragraph 2, subpara Roman 2. Now, the Roman 2 paragraph last line, when it's the line starts from similarly. Similarly.
Yes.
Similarly, if the ward of a junior high, secondary, higher secondary school teacher or of a teacher of such education institution under the school education directorate or a non-teaching employee attached to the junior high, secondary, higher secondary school or other education institution under the director of school education who dies in harness does not possess the requisite qualification for appointment as a teacher in any of the said institution, but possess the qualification for appointment as primary school teacher and opts for being appointed as such.
So when your father died, was it in operation?
Yes, 1997, my father died.
Yes, and this is of 87 circular. In between, you have this 1991 recruitment rules.
1991 recruitment
So
rules.
if it is prior to 1991, what you are saying may be correct. Please come at 2. I tell you the reason. We want to, Mr. Bhattacharya was here. We want to know from you what would happen to those where the disciplinary proceeding would not be concluded. Could not be concluded. And in terms of the 2018 rules, what would be the consequence of it?
My lord, if to be concluded, then you
Please come at 2 with this.
have kept the brief at home.
No, just come, Will. So this is governed by your 1991. The 1991 has given us specific provision. This will override any other earlier provision.
And I made application to the district inspector of school AC, secondary education.
Yes.
But now it is the DIAC, my lord, who forwarded my name to the district
No,
primary
no,
school
he
council.
says that he will not be eligible because of this 1991.
Yes,
Yes, so if you are not eligible under 1991, then how your case can be considered?
my lord, if
If
1991
you
reverse
show us the provision that this, it's a circular.
circular.
Now, this circular is superseded now by this notification. If it is superseded by this notification, your appointment has to be considered on the basis of the notification. Compulsion appointment is not a vested right.
No,
Then-
that's true. But what I am trying to say, my lord, my father was a high school teacher. So
But
there
that is
must be,
provided, that is provided your, this rule two is applicable to you under 87 notification.
then I am not entitled for primary school teacher. Then
Show us that after 1991, there is any such provision made applicable, because 1997 is very clear. 1997 is very clear.
1991, my lord,
Yes, 1991 is very clear.
yes, my lord, kindly 2M,
It's
my lord,
because now it will be governed by Rule 14 of the notification of 22nd November 1991.
1991.
Then
This is a
show
rule,
us-
my lord.
These are the only ground on which it can be.
But now definition of teacher 2M, it
Yes,
says teacher must be the primary school teacher.
yes.
Now, my lord, kindly see the conduct of the respondent authority. I never,
Conduct is different.
no, my lord, I never opted for primary school teacher. Kindly see my application. They should have appointed me as a clerk or group D staff in high school also. But kindly see my application,
Now,
my lord.
provided that is permissible.
That is permissible,
My lord.
yes. But kindly see my application, my lord, page 24 for once, my lord, stay application.
My lord, may I submit one thing, my lord? Appellants.
This is may appoint primary teachers, fine.
Yes.
So your application is not for primary teachers.
No, kindly see my application, page 36 of the stay application. To whom I have made application. Page 36. This is the pro forma form supplied by the office of the district inspector of school, secondary education. (36). Kindly see top application form for registration of the name in DH cell of the district inspector of school AC Tamluk, Medinipur, in the post of teacher or clerk or class 4 staff as a DH candidate in terms of director of school education notification number so and so. Here, my lord, there is no column for opting any post. Commensurate my qualification, they will choose. But my qualification, I have written MP. Next page, my lord, page 37.
Yes, yes.
Paragraph 2. And it was forwarded to the district inspector of school, secondary education, Tumluk, Medinipur. Top, bottom, my lord, kindly see, forwarded to. And this form was submitted to DIAC, page 38, by the school authority, page 38. Then my act completed. Now it is entirely upon the respondent authority, my lord, where I shall be appointed.
Yes, what you say?
My lord,
Will not
may
be
may I submit one thing, my lord? My lord, pursuant to order of Honorable High Court, the Director of School Education passed order and rejected the prayer of the petitioner, my lord. the writ petitioner challenged the said order before the Honorable High Court. But in the writ petition, the writ petitioner deliberately suppressed the material facts.
What
The suppression of fact that his mother was the primary school teacher in a school.
suppression of material fact will not be available to you because it was hard on merits. So you are supposed to file your affidavits. So you must have taken that point before the learned single judge.
My lord, the learned did not consider my supplementary affidavit and also affidavit opposition, my lord. Kindly see my affidavit, supplementary affidavit, my lord, page 70 onwards. And also affidavit in opposition. The learned trial court did not consider my opposition and supplementary affidavit. And also the petitioner stated that he lives separately, though his mother received the family pension, my lord, entire things, my lord.
No, but now what you have said is not correct. Now that you are saying that she applied, she has not applied for primary teacher. Your case before us is something different.
Well, can you see the infant order passed by the DSC, my lord?
Your report is before us is something different.
And the Commissioner of School Education rejected my prayer on the same ground.
Well, 57 for a moment, my lord.
First difficulty is this, that unless you show a rule, the compulsion appointment is only against a primary teacher. It does not say that you can be considered for any other post. There is nothing in 1991 which shows.
1991, if not applicable to me, then my lord, the concerned rule applicable where my lord, I can be appointed in high school as the non-teaching
No,
staff.
but Commissioner of School Education has proceeded on the basis that only you can be only considered provided for the post of primary teacher, not for any other post. So that is the first thing.
I can be
And
appointed.
then the family income. If the family income is this, then this family income is not justified for an appointment.
But family income, it has been short at 7,154. My lord, where my elder brother was suffering from cancer, man-eater disease, cancer, my lord. Your lordship knows, my lord, how expensive is this. And my lord, due to non-treatment, my lord, he died in the year 2019.
No, but
Kindly consider this, my lord.
it's in 1997 and we are in 2023.
My case has been transferred to the district primary school council. The respondent authority transferred it. I have not. I have prayed for only one post. Beggars have no choice, my lord.
What was the elder son doing?
But he was doing business.
Businessman,
Not the same.
each elder
same
brother
because-
being a businessman.
Financial need is not proved.
My lord, I've stated in my supplementary affidavit in details. my lord.
Financial need not proved.
Kindly consider 7,154.
No, but
Lord,
also
kindly
your
do not
brother had a
generalize all,
business,
my lord, because kindly consider my elder brother's disease.
but he is no more alive.
Now he is no more alive, my
So
lord.
that has to be financial.
Had me given any appointment, my lord, I could have saved him. Kindly consider the ground reality, my lord. This is their mistake. They have sent my application for teacher.
But why you have sent her application for teacher? Not
My lord,
for-
pursuant to order of Honorable High Court, Justice Devashish Korgupta, my lord, the Commission of School Education heard the matter, my lord.
Just-
And at the relevant point of time, appointment on competition ground in primary school, my lord.
Page 55, order passed by Honorable Justice Korgupta. Page 55 of the stay application.
Was any recommendation in your favor?
Yes, the council
No,
has.
no, no.
Where
this
is
is-
There
where
was
is-
no
where is-
finding at all.
Council has recommended my
Page.
page, my lord. I'm showing my lord, page. Page 49. Twice recommended, my lord. Page 49 and 50. And my lord,
One recommendation করেছে।
Recommendation for appointment of primary teacher, my lord. But the rule is not permissible.
No, where is the recommendation for his a primary teacher? It's not that.
উপরোক্ত বিষয়ে শারীরিকভাবে মৃত শিক্ষক অসিত কুমার সিনহা ও তার পোষ্য তথা প্রার্থী শ্রী অপ্রদীপ্ত সিনহার সমস্ত তথ্য সহ কাগজপত্র এত প্রেরণ করা হলো প্রয়োজনীয় অনুমোদনের জন্য ফর অ্যাপ্রুভাল অফ দ্য কমিশনার
There was no finding.
did not say any post, mention any post.
He has not mentioned any post.
My lord,
He has not mentioned any post.
there is no findings of sufficient in the,
He has not asked for any post.
my lord.
So how he proceed on the basis of a post?
Approval of appointment of primary
At that
teacher.
point of time, the concerned
Oh,
municipality has certified that my family is suffering from financial
কত
distress.
বললে ওটা? Okay, post, my lord, page 50A, my lord, kindly.
Approval of appointment primary teacher of the ward of the
Post for approval for appointment as primary teacher.
Yeah, no.
of the ward of the primary
all are,
teacher.
as per the data with documents of permanent incapacitated, his word is sent for that approval for appointment. Oh, this is the approval for appointment. So this was, he cannot be appointed as private teacher. The approval was wrong. But difficulties is when the approval was made, it can only be approved in terms of Rule 14. That is the point. And the chairman was correct. He said the recommendation was for the post of appointment as a, you may ask for any post, but the approval was for the post of primary teacher.
Yes.
Now that was turned down and the commissioner said yes, because he is not qualified for the primary teacher.
I am
So-
not qualified, then why my name has been forwarded as the primary student? I am asking this question to
No,
myself,
then this recommendation is wrong.
my lord.
Then this recommendation is wrong.
And commissioner also stated suppression of facts.
I have only applied for.
Take down.
I did not choose any post, my lord.
That's a different issue. এই শোনো, আচ্ছা ঠিক আছে। The appeal is arising out of an order dated Yes. Yes, for the list.
Much obliged.
Dispose. Item number 3. And item 3, I appear for the appellant.
My lord, I am appearing for the school authorities. I have been led by Mr. Saptangshu Basu, who is online. My learned senior.
Why he's online?
Lord, I am in Jalpaiguri. In Calcutta High Court, nowhere else.
He will not be allowed to make double profit for you. Double income. Yes. You are for the appellate. Yes.
The case is, in a nutshell, that I am an unapproved teacher of a DA grading school. Now, I have applied for approval of my appointment before the District Inspector of Schools, Kolkata. Now, that was not proceeded by the school authority. Now, I approached the High Court, praying for a direction upon the District Inspector of Schools, Kolkata, to consider my case for approval. Because I am a English teacher, language group, I am in the school for many years, and I want to get myself approved to get the DA. Now, your Lordship will have a look to the order improved before your Lordship. Stay application, page 61. Since 2012, I am working. Mr. Basu, learned senior advocate, counsel appearing for the respondent number 4 and 5 school, submits that a disciplinary proceeding is being contemplated against the petitioner and it will be initiated soon. And that is why the steps for approval of a service could not be taken. Then I direct the school to take immediate steps within 4 weeks from the date in accordance with law as per the amended management rules of the West Bengal Board of Secondary Education, if they really want to initiate disciplinary proceeding against the petitioner. First of all, it's a DA grading school. It's a private school. Well, in a private school, this rule of management rules doesn't apply. One, this is of 2018. Disciplinary proceeding rules doesn't apply.
So you have applied for approval to
before the district inspector. Approval of my appointment.
Because your DA will be paid by the government. Now, what happens to his application?
But here, Lordship, let the school forward the name of the district inspector of the school.
We have not we have not forwarded.
So he filed an application to you.
No.
Yes, directly. Yes.
But the petitioner did not directly file the through school.
But you cannot file an application without.
Your Lordship kindly have a look to page 55.
He cannot anything send.
No, but can you file an application directly?
No. I have
the school because if you are not approved teacher, then essentially it's a dispute between you and the school.
Yes.
You and the school. Once the school recommend, once the school recommend, because against your name, the school will receive DA which will be passed on to you.
Lordship.
So that is why when the school recommends you, then question of depending upon the staff strength and other pattern should be considered that whether against that particular post it will be approved or not.
Lordship. Now, can you turn to page 40?
Yes.
Since 2012, for last 13 years, I am discharging my duty. Now, I have approached the secretary of the school management, requesting for sending my name to the district inspector for approval. It was in 2019, after 7 years of my appointment. That has not been done. Kindly have a look to what is it?
Is it a DA getting school?
DA getting school, Lordship. Palika Shiksha Sadan, Lordship, the DA
getting school. There are vacant posts.
School, Lordship, without school, the name, Lordship, I can't.
Question is this: they cannot decide on the question of your approval unless the school recommends.
School is not. That is why I have a
school recommending. If the school is not recommending, it's a private school. How we?
It's a private dispute.
Tell your Lordship.
How? On what?
I tell you, Lordship. I'm giving that handle to your Lordship.
On what basis we can?
I give the to your Lordship.
What handle?
The government comes into play. Yes.
I tell you, Lordship.
We may not say that this the last direction we may set aside.
Lordship.
The question
but
is
I tell you, Lordship, what is the
what is the rule for this?
Yes,
Well,
what is the
kindly
rule?
have a look to the rules. Well,
If the school is not forwarding for a private school, what is DA getting school, let us say DA getting school. What the right of a teacher in
but
such-
may I get the headmaster
yes.
manual for once?
Headmaster manual টা দাও এখান থেকে।
Well, because in my copy, well, the rule is not there. No, no, no.
এটা কি
হ্যাঁ,
মাদ্রাসা
ওটা, 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 ওটা,
মাদ্রাসা
ওটা,
দিচ্ছ?
ওই, এটা আমাকে দিন, আমাকে দিন, give it to me.
ওনা,
This
ওনা,
one.
ওনা, ওনা, ওনা। এই গুরুপদ তুমি একটু একে
Headmaster manual তো।
ও এটা ওয়ান ওয়ানে থাকবে ওয়ানে টু আছে এটা লাগবে না ওয়ান আছে
One.
টু আছে টু
460.
what is the remedy available? Mr. Vashi?
Well, I tell you, Lordship. Well, your Lordship kindly turns to page 462 of this book. This book. এটা জশবকে দিয়েছেন বইটা?
না না বল দে
জশবকে এই ভলিউমটা।
ও তো বল না
1691
1691
1691
page 462.
এটাও তাই সেম
Hmm.
সেম
One second. This is the notification of 20th September 2001.
অঞ্জন একটু পড়ে দে
Well, kindly have a look to the notification. Filling up the vacant post within the government sanctioned strength of the schools in receipt of the DA from the government. Well, I am skipping the first paragraph, second paragraph. Authorities of some DA getting schools have approached the government in education department to fill up the vacant posts against sanctioned vacant post, sanctioned strength of such DA getting schools by placing teachers working beyond the government sanctioned strength, since for non-consideration of their candidature at the time of filling up the post within the government sanctioned strength, the senior teachers are being deprived. Then, government in education department has since considered the matter at length and decides to permit the authorities of such DA getting schools to fill up the vacant post within the sanctioned strength by placing properly qualified teachers already working in the school for the secondary high secondary section, but not in receipt of DA from the government on fulfillment of following conditions. 1. Such teachers working beyond the sanctioned strength should.
sure
You are missing the
yes
question is the school has to forward.
Yes.
If the school is not forwarding,
Yes.
can we compel the school? The school may have reservation against you.
But I tell you, Lordship.
Yes,
But
we cannot
I
decide on
tell
that.
you, Lordship. But why I am placing this? But I tell you, Lordship. If there is vacancy and but I am the senior most teacher, the school must send my name on the basis of this notification. The school has not done so.
May have reservation, we may have not approved you. School may have against reservation against you.
But school cannot have any reservation against me until and unless.
This only rule permits the school authorities to
Yes.
forward the name of the teachers for approval by them.
Working beyond the sanctioned strength who are senior most.
This rule does not give a right to a teacher for a direction upon the school to forward the name for being considered by them.
Yes, but kindly allow me for 1 minute. Kindly look, kindly read the first proviso. Such teachers working beyond the sanctioned strength should be placed whenever any vacancy arises. School.
When the approval has come.
No.
Yes.
This is prior approval. Prior to approval. Kindly read the earlier provision. The government in education department has since considered the matter at length and decided to permit the authorities of the day getting schools to fill up the vacant post within the sanctioned strength by placing properly qualified teachers already working in the school, but not in receipt of DA from the government on fulfillment of following conditions. So, if I fulfill the following conditions, only then my candidature will be considered by the school. Such teachers working beyond the sanctioned strength should be.
Decides to permit.
Yes.
So
enabling provision.
Then
from whom? From such teachers.
Yes, working beyond the sanctioned
But
strength.
suppose- See, the question is this, that he will permit.
Yes.
So you are saying you are a teacher working beyond the sanctioned strength.
Yes.
That is for them to send your name
Hmm.
for being considered
Hmm.
that if you fulfill these conditions.
True.
But we cannot compel the school to send your name.
But now your lordship kindly have a look to next point. Should be placed whenever any vacancy arises within sanctioned strength in. But kindly read for once. Kindly read. whenever any vacancy arises within the sanction strength in strict adherence to the norms of the staff pattern of the so and so, only those teachers who possess so and so. So, my lord, then your lordship kindly,
Since you are qualified, your names are not being forwarded by the school. We cannot
Yes,
compel. How can
yes.
we compel on what basis?
my lord, now your lordship kindly sees the authorities. Then second paragraph. Authorities of some de-educating schools have approached the government in the education department to fill up the vacant posts against sanction strength in de-educating of such de-educating schools by placing teachers working beyond the sanction strength for non-consideration of their candidature at the time of filling up the vacancies.
Management rules will not apply.
No. Then
Not apply.
No. Within the sanction strength,
I also say not applied, but we have reservation. There is a proceeding initiated by us, particularly this candidate.
but let senior teacher.
Management rules will apply.
No,
For DMED
that is why but let this notification.
Doubt not see school, if the school for no lord.
this amended management rules of the.
This will apply, this will
No,
apply.
no.
This will apply.
Not at all. Not at all. No, not at all.
No,
But
this
irrespective of that, is it applied, not applied, my lord, we have initiated proceeding against him. How we can recommend?
Where is that?
just a minute. So the West Bengal Board of Secondary Education. I direct the school to take immediate steps within 4 weeks.
Initiated.
This management rules of West Bengal Board of Secondary Education is applicable to them.
No.
Why not is not applied?
No. But let kindly see the rules.
For getting school, this
No, it is Joseph ke din.
School nursing management rules not
Hey,
applied.
not apply.
No.
No, not applied.
It may apply to the person who has approved.
Yes.
No, even not approved.
Not applied management.
Management rule doesn't apply. Kindly see but the institution but column. The thick portion.
It is
Institution
not applied, not applied.
provision applies.
Institution refers to schools as defined in clause N of section 2 of the West Bengal School Service Commission Act. So 2N is getting school is.
My lord, may I hand over, subject to Mr. My learned
Yes,
senior,
yes, देखिए दे.
may I hand over rule 28B of the amended rules after the gazette notification? It will apply.
Apply.
Non-government unaided organization, this rule will apply.
Non-government,
Unaided organization. We are non-government.
but aided organization.
Aided only to the extent of DA,
De-grading.
only to the extent of DA, not any other government aid.
But the committee of a recognized non-government unaided institution.
দুটোই তো কপি আছে না?
So committee is required to be recognized.
Yes,
The committee is not recognized. The management is not recognized.
the question is this, we have to forward the name to the board. Thereafter an inquiry has to be conducted.
Normally, the managing committee, if you take a decision with the approval of the board, you can initiate it.
Yes, that is what we have done. That is what we have done here in
The
in this
management
case.
rules
Just a minute,
1970
let me explain. This is what we have done in this case because we have reservations, what has fallen from your lordships. We have reservations about this particular teacher. She has violated the discipline of the school. She indulged in indisciplined behavior, did not take classes, incited the students to join movements, blocking the main door, main entrance of the school. These are the things which have been done.
What is our grievance?
Grievance, my lord?
What was the grievance?
Grievance is that we have to initiate a disciplinary proceeding because
What was the grievance of the teacher?
grievance of the teacher is that his name has not, her name has not been forwarded by us. That is the only grievance. She is trying to compel us in an unlawful manner to forward her name.
That the order of the
This is
single
what
bench
this
was passed.
cannot be allowed to.
The order of the single bench was passed in February 22. Till date, nothing has been.
Yes, we have done. He is misleading. He is not informed particularly. We have forwarded his name. I have specific.
Don't use misleading.
Your lordship,
Where is that?
just a minute. You are not
Don't
your
say misleading.
forwarded the name to the district inspector of schools and the board.
First, want to know from you. No, but first we want to know from you whether your permission is required or not.
But let's say, as well as the.
আমাকে একটু বইটা দিন না। Blue বইটা।
District inspector has to conduct an inquiry. We have forwarded it to the commissioner.
Whether at all it is required, that is the point.
No.
Private school.
No. হ্যাঁ ডিআই কন্ডাক্ট করবে
Well, kindly sees the question, well, kindly sees the definition institution. Institution to a school is as defined in 2N of the West Bengal School Service Commission Act. Well, School Service Commission Act doesn't apply in DA grading schools. It's complete bar. The DA
But
grading
rule
schools,
28B has been inserted by this gazette notification.
kindly sees,
Non-government unaided organization.
kindly sees, well, Rule 28B. If the disciplinary rules of 2018 is not applicable in DA grading schools, how will the learned trial judge has sent the matter for disciplinary proceeding?
Rule
Is a- is a-
28B is clear on this point.
Absolutely, kindly sees, well, Rule 28B.
So who is appearing for the board? Who is appearing?
Let's see, H1, let's see, give me, let's see, one day time, let's see.
But who is appearing for the board?
Otherwise, let's see, it's my board in no authority, let's see, in this matter, let's see.
Board has no authority.
Board in no authority, DI, let's see, say, let's see, 28, say, let's see.
Because I tell you, Your Lordship,
But,
in
but one thing,
2018 rules,
Not
the
DI.
disciplinary proceedings rules 2018 doesn't apply in DA grading schools.
but one
So-
thing, my lord, may I just summarize to assist your lordships? We have reservations about this particular teacher. We have initiated the disciplinary proceeding. We have issued show cause and the
Where is
inquiry
that?
is pending. And the inquiry is pending. So
Nothing
at
has
this
been given
stage,
to me.
at this stage, the appellant cannot pray for a right to
But Your
forward her
Lordship,
name.
kindly have a look to Millet, what they have given to me. Nothing. Let them prove a single point.
The petitioner is working in the Balika Shikha Sadhan
Balika Shikha Sadhan.
since 2012. Her grievance was that the school authority
Millet, only
not
one request.
nothing for approval. The school concern is a DA grading. For the learned single judge who has contended on behalf of the school that disciplinary proceeding is being contemplated against the petitioner and it will be initiated soon. And that is why the steps for approval of a service could not be taken. We have been informed by Mr. Shaptangshu Basu, the Revenue Senior Advocate, that permission has been sought from the board. Permission has been sought from the board.
No, Lord, sir, not necessarily for the board.
He said.
তুই
But
বল,
Lord, sir, I
কার-
accept-
কার কাছে গেছিস
Permission
permission?
has been sought.
Then let's see, that's,
This disciplinary authority, thereupon the discrepancy of the forwarded the complaint against the teacher through district inspector with a copy to us to conduct a preliminary investigation into the charges levels against us to send a report to the board within 30 days from the receipt of the letter.
Millet, neither the DI nor the board is the authority.
The DI, the authority.
No.
The inquiry is to be conducted by the DI as per Rule 28B.
Let's see, Lord, Rule.
Inquiry is to be conducted by the DI after forwarding. the-
Otherwise, we will do it. If it is not legal, then we will do it. We appoint a proceeding has to be initiated against him.
Direct the DI to inquire and find out.
Yes, yes. Kindly do that.
Query anything, Lord, sir,
It is a private teacher. How the DI can Millet inquire about me?
So this read is not maintainable. Because he is asking a mandamus against me.
That point was never taken. 373.
It's a question of law. I can take in any point.
Although it was submitted that necessary permission has been sought from the DI
DI. DI is conducting the inquiry. We have forwarded the complaint to the board.
for initiation of disciplinary proceeding against the writ petitioner. However, we are not required to go into such question as prima facie it appears that the school is a private DA grading school and the and the restriction of the DI to go into such matters is required to be on into and may be decided by the board for whom such request was made. Mr. Bhaskar Prasad Purisho, the Lord Advocate for the state, has submitted that relevant rules referred to in the order may not be applicable to the institution. Either as it may, the approval for the post can only arise provided the name of the teacher is recommended only when the name of the teacher is recommended by the school. In absence of any such recommendation, no writ of mandamus can be issued to the board for approval. In absence of any such recommendation, no writ of mandamus can be issued upon the board for approval or consideration of the case of the petitioner for approval. Also,
It is not the board, the DI will approve.
ultimately the board.
No, no, no.
DI is schools,
Kolkata.
schools, Kolkata. Under such circumstances, we take the stop. We make it clear that whether the school will initiate a disciplinary proceeding or not, it is for the school to decide. And the observation of the learned single judge cannot be taken as an approval for initiation of disciplinary proceeding on the basis of charges levied against the head teacher.
Great.
My lord.
Good.
I think that's-
My right to get approval. I am, when the writ petition was moved, there was no disciplinary proceedings pending against me. They said it will be.
Item number 4.
Please, your lordship, I beg to appear for the petitioner. On the earlier occasion, lordship was pleased to pass an order to serve upon the evidence of service.
Yes. Yes.
This case has a special feature.
Yes. Yes.
Lordship, come to page, my original appropriate order petition, Annexure B, page 24, 24th day of August 2015, passed by the earlier division bench order. Kindly come to page 27.
Yes.
At the last portion, we are therefore of the view that the implement order dated 18 November 2013 passed in WB such and such so and so. It is accordingly set aside and the appeal is allowed. However, we cannot lose track of the fact that the respondent teacher is a lady teacher who has been transferred to a remote village. She is residing in a remote village corner. She has been started from bus, thereafter train, thereafter auto rickshaw. 272 kilometers from our residence. Similarly, she has to again travel such and such so and so. This, according to the learned counsel appearing for the respondent, is not only harassing and troublesome, but it has been going on for that last 16 years. Now 2023, 23 years gone. It is very unfortunate.
Yes.
By availing so many criminal activities, rampant.
Concentrate on the facts, not on any other thing. What is it?
We therefore, while allowing this appeal, give her liberty to apply before the School Service Commission strictly as per Rule 6, and as soon as such an application is filed, the Commission or School Service Commission shall pass appropriate orders in accordance with law, keeping in mind the aforementioned special feature that was mentioned by the learned single judge in the implement order. With the aforesaid observations and directions, the appeal stands allowed. The aforesaid order has been passed in the pending appeal, and since the writ petition itself is pending, we direct the learned counsel appearing for the appellant as well as the respondents to produce a copy of this order before the writ bench, which is in session of the matter, so as to assist.
Dr.
this-
Patro, her service was not confirmed or approved.
My lord, that appears from the,
No, but if you go by the order of the division.
yes,
bench,
yes.
Then it's approved.
No, that the state will be able to, because we do not. That's not been approved.
No, but if it is not approved, then how the division bench, earlier division bench can say that, allowed the appeal giver liberty to apply before the school service commission as per rule 6 for general transfer. If it is not approved,
Rule 3 will attract.
this, huh?
Rule 3 will be.
No. Since when she is working?
Suppose from document it shows that. That's 1998.
It was not approved for all these years. Why? Why?
No steps have been taken by him also. She also.
No, but he was taken to be, she has to take a stand, step for approval.
No, nothing has been done, my lord. It has not, service has not been approved.
See,
90.
yeah, he was aware of this fact and upon the DI to transfer the petitioner to Rudrapur. So that was a subject matter of challenge in 2015. And there it was never asked that her service was never approved. That was not the plea taken. How can you take some of the such?
But the document says so. If you also so these are
How can your document says so? You have not said in 2015.
that I have to stay.
You cannot dance to the tune of the ipsy of your person.
No.
Then
But kindly direct that, so that I can apply your lordship.
what direct? You should have been here with this instruction. Why you should direct you? Why we should direct you? You have to address us that how this
1998, why it has not been approved on that issue.
doesn't show that this point was ever urged in 2014 when this matter was taken up. It was basically on transfer. It was basically on transfer. Then transfer of a regular teacher. Rule 3 and 4 will apply to only regular, isn't it?
Regular teachers.
Then, so when the rule 6 was made applicable to her, that means she was a regular teacher.
That's what I have to take specific instruction. Going by the date of appointment of the teacher, it appears that she was selected prior to the School Service Commission. 23rd. Not prior to the February, act, but prior to the 1999. first selection process which we conducted. So she was not selected by the commission.
But she may not be selected by the commission.
But if she is approved and a regular teacher, then naturally she will
Rule
get
6 was made applicable to him.
only to the permanent.
Rule 6 was made applicable to on what basis?
But there is one observation that she was not attending the school.
That's a different issue.
That might be the reason for not giving the approval. That
But-
my learned friend
But,
will.
but which period? A person who
Yes,
has
of
joined
course.
after, he may not have joined for say, for 1.5 years. 19 days, you proceed against her. That's a different issue
11-1.
for non-compliance. Then take down.
Can want us to discuss.
Can want the.
Can one is
Item number 5.
My lord, item number 5, my lord. My lord, I am appearing for the appellant, my lord. My lord, in short, my lord, I have, আপনি আছেন sir?
আমি ইয়ের
Petitioner,
কলেজের হয়ে
college petitioner.
No,
My lord, I have served, my lord, this is my affidavit of service, my lord. My lord, in short, my lord, matter is, my lord, petition, my lord, my lord, after getting PhD, petitioner is entitled to get, my lord, some increments, my lord. Now, my lord, in this case, my lord, petitioner got 2 increments. My lord, as per UGC's guideline, I will show, my lord, in short, my lord, I am just submitting. In short, my lord, petitioner is entitled to get 2 increments as per UGC's notification, page 46. And state government adopted that, that is page 47. Petitioner filed one writ application challenging the order of page 47. And petitioner claimed that he is entitled to get 4 increments. The state government notification is not correct or proper. My lord, honorable single judge was pleased to set aside the state government notification and hold that, my lord, petitioner is entitled to get 4 increments. My lord, thereafter contempt, and my lord, we complied the order. Petitioner now get, my lord, 4 increments. But, my lord, for academic discussion, my lord, I am placing the appeal. Because, my lord, if we do not move the appeal, my lord, then, my lord, floodgate may be open. This is a short point is involved in this matter.
About the issue of the compliance, you are not interfering, but this order shall not operate as issue. Or as it is.
My lord.
My lord, we beg to appear on behalf of the college, respondent 3. In the read, we give our affidavit in supporting of the claim of the petitioner. It's in page 72, from the order of the writ, it can be reflected.
Where is your letter of compliance?
My lord, compliance, my lord, that is not with me, my lord, because, my lord, we have complied, my lord. Before honorable single judge, we have complied.
You see your letter of compliance, that is important. Where is your letter of compliance?
My lord, that is not part of this appeal, my lord. Subject to kind.
If you have unconditionally accepted it, there is no question of, then this appeal is not maintainable. If you accept this order, reserving your right to prefer an appeal is one thing, but if you accept this order without reserving your right, you cannot.
My lord, subject to kind correction of your lordship, my lord, under the threat of contempt, my lord, if,
No,
my
no,
lord,
your letter
my
will
lord,
speak for itself. Not under the threat of your letter will speak for itself. That whether in the threat of contempt you have done, or you have done it on acceptance. Because if you accept this, because your appeal is also barred by limitations.
Yes.
my lord, last day, my lord, your lordship was pleased to allow the section 5 application, last Tuesday. Yes.
But if you accept this without reserving your right, then under the codal procedure, no appeal lies.
My lord, I want to, my lord, submit before your lordship that, my lord, to that effect, my lord, honorable affects court judgments are there, my lord. My lord, today, my lord, I am not with armed.
No, this, your letter of compliance must record that is serving your right to prefer an appeal. It has happened, we are entertaining. But where it has not been said, so we are
No, my lord, no, my lord, it is not there. It is admitted position, it is not there. My lord, very honestly, my lord, I am submitting before your lordship, it is not there.
your unconditional acceptance of the order you and implementation of the order
Six, my lord, I'm for the appellant petition. My lord, this is a matter, my lord, issuing of a appointment, and my lord, your petitioner appellant was participated the recruitment process under the district primary school council, North Chobbish Pargana, for selected a assistant teacher. Now, my lord, the examinations completed in 2014, written examinations. After successful the written examinations, Viva voice was completed on 22nd November 2014. Now, my lord, there is no any response after completed the Viva voice. And another hand, my lord, as per recruitment rules, all other criteria has been satisfied by the candidate, as well as educational qualifications and BEd examinations, any other criteria. Now, about in connection this matter, two order has been.
No, but you have not participated in the
TET, my lord, the TPSC, that is District Primary School Council.
Yes. State is separate thing.
Separate things.
State is the state government introduced in 2011 West Bengal Board of Primary Education.
But where he has participated.
But a TPSC, lords.
2009.
2009. But lordship is the below cut-off marks.
That is Pent Authority is the
Cut-off marks.
chairman.
Here, lordship, cut-off marks is lordship.
No, no, 22.
Lordship, he get the 20.46. And lordship, marks is 30 point, last marks is 30.67. এই হাই of the paragraph.
আমাকে একটা কবে দিন স্যার? স্যার আমাকে একটা দিন।
Last lots.
Yes, so you are not a TET qualified.
Not that qualified, that on that ground, not the read petition has been dismissed. He
this-
say, I am qualified in the TET. No. He qualified, he examination the DPS. I further, I said maximum marks of stating 35.95 in the approved panel of the primary recruitment person, the UR category, and the minimum marks of impanel candidate, Urdu candidate, into 30.65.
District primary school council raised from document modified 23rd April 2020 for recruitment of primary
Item number 7.
My lord, in item number 7, I am appearing on behalf of the respondents, my lord. Respondent school. My lord, I am at the very outset. At the very outset, I am raising the point of maintainability.
Yes, my lord, your lordship.
Because the law has been settled by the Honorable Supreme Court in
No,
2020.
my lord,
I am just producing
my
the
lord, sir,
decisions.
my lord,
My lord, kindly cease.
appellant, my lord. But this question, my lord, whether the writ petition is maintainable against the unaided school or not.
Because it is a private contract. It is a contract between two private persons, no public element, law element in. My lord,
I being the appellant, my lord, kindly
cease, my lord. This decision of Honorable Dhruv.
Tell us what is the matter.
yes, my lord. My lord, kindly see, my lord. This is my lord. This is the notes, my lord. I prepared notes. My lord, kindly. My lord, notes, my lord. My lord, page 2, my lord. My lord, paragraph 4, my lord. Notes 2, my lord, paragraph 4. The appellant further state that after induction of Article 21A into Part 3 of the Constitution of India, the right to education has been enshrined as a fundamental right for all children. It is furtherance and giving effect of such fundamental right, the Parliament passed Right to Education Act 2009, which has been given effect from 1st April 2010 onwards. Section 2A of the said Act defines a school in the following terms. Kindly see, then room 4. An unaided school not receiving any kind of aid or grants to meet its expenses from the appropriate government or the local authority. Now, this is the school meaning. Then it may be mentioned here that clause A of subsection 2 of the section 38 of the Act provides the appropriate government as defined under section 2A of the Act, which power to make subsidiary rules. It is pertinent to mention here that section 38 of subsection 2 of the said Act has empowered every state government to formulate grievance redressal mechanism. Then paragraph 5, that in pursuance of such power conferred under section 38 of the Act of 2009, the state of West Bengal had also framed the rules in the name of West Bengal Right to Children to Free Compulsory Education Rules 2012. And under Rule 17 of the said rules 2012, there is a grievance redressal mechanism which casts responsibility on the school to develop such mechanism. However, in default of such, that is, if the school failed to formulate the grievance redressal mechanism as provided in the rule, then apparently it would be tantamount the patent manifestation of the violation of the right of an employee under the Act 2009 read with Rules 2012. Well, further to state that Rule 17(2) of the said rule also provides where the school management committee failed to address the grievance or where the teacher is dissatisfied with the decision, appeal may be made to the West Bengal Administrative Adjudication and School Dispute Commission. Admittedly, in this case, there is no mechanism of the school management to address the grievance raised by the appellant, as well as in the state of West Bengal, there is no administrative commission framed by the state in terms of sub-rule 2 of Rule 17 of the Rules 2012, according to the fit case for judicial review under Article 226 of the Constitution of India. Now, then paragraph 6, it is germane to mention that the petitioner had also came to discharge a public duty as was cast upon it by the statute in the unaided school, which ran responded by virtue of section 2N of the Act 2009 coupled with Rules 2012. Such public duty stands obligatory in terms of both Article 21A of the Constitution of India as well as Act 2009 and Rules 2012, which gave effect to the fundamental right and unequivocal terms. That it need to be indicated that the respondent in a private unaided institution imparting education to student, which is otherwise a primary function of the state and which is performing function and public duty. Notes. This is
notes. Short point.
Short point, as per the kindly see, this is the Act.
Short point. Forget about Article 12 or not. Question is this: you were joined as an assistant teacher on 6th November. Thereafter, you joined the post of principal on 26 March. And you resigned on 29 February. It's accepted on 2nd March 2020. The conclusion was that the court notices that the resignation for the post of assistant teacher and joining as a principal automatically means that the petitioner was absorbed in the regular post of principal and was functioning as such. The petitioner cannot now turn around and enforce a contract with the school as seeking benefits of the assistant teacher. Absolutely correct.
But because the assistant, this is the this is the recording that I resigned from the assistant teacher. But this is not fact. After March 2nd March, the school I am doing the job and the salary already released. I doing the April, that this release the salary up to April and up to July, I continue the class. But if they accept the resignation, why they allow to continue with the classes? And also they release the salary for the month of April.
Have relied upon said that the service of the teaching and not teaching staff that you have relied upon in paragraph 10 shall not be terminated. Your case was not terminated. You resigned. There's a distinction between resignation and termination.
Yes, but this is not this is a termination, but as per if
What is your letter?
resign, this is the principle. I am additional charge.
What is your letter? He said, I am resigning or not.
Resign for the post of principal. Additional charge, but I am being the assistant teacher.
It's the letter of your resignation. Let us see. So, and principal is a superior post than assistant teacher.
Yes, but I'm taking charge, but if they are
You are not. Where is your letter of resignation? Show us. Yes. And there is nothing to show that you have been given an additional charge. Assistant teacher to principal is a promotion.
because
So, you cannot have both assistant teacher and a
no, but it's the addition there in the meantime. Already, but there was a principal.
one. It's a promotional post. It's a promotion. Are you receiving the salary of the assistant teacher while you are principal? No. Then you are not officiating.
Salary is same.
So
But
what
salary
I
same. Salary same.
say that now I want to release from this post on account of some personal reasons. Though I will be released from this post, I will continue to play my educative role, showing directly connected with your student as usual. I hope that I will be able to continue to take part in the progressive approach of your school.
If they accepted my resignation, why they continue me to the post of assistant teacher up to the July and also release salary up April? Their statement is they accepted the resignation on 3rd March. 3rd March.
Period of 30 days.
April release salary and also continue up to teaching teacher up to July.
He said that I hope that I will be able to continue to take part in the progressive approach.
As why this is an additional charge, but
Where you release the salary with the capacity as an assistant teacher.
assistant teacher.
So where is the release? Was
না স্যালারিটা দিলে ওটা কোথায় এখানে কত স্যালারি দিয়েছে দেখুন
So your provident fund contribution was taken up to March or not up to.
kindly see Malad, this is the
No, no, your.
bank Malad, bank passbook Malad, the
Your
on
provident fund-
24/4/2020
your Provident fund contribution was taken up to March.
for release salary and
Your provident fund was deducted after the resignation. You show us for all future payments, whether your provident fund. contribution
salary Malad released.
Up to the date of resignation. After when you receive the amount, there is a CPF fine. And this, is there any contributory provident fund?
No, no, Malad, this is at the time of Malad, the COVID. Malad,
Don't say anything from your, come to page 30. How long you contributed for the provident fund? How long? After the resignation letter, did you contribute for the provident fund?
No, Malad.
Then
But
it's accepted.
But kindly see the salary Malad release and contribution class.
Salary increases. You see, you yourself have said that after this, I will be at your service whenever you require. So they have continued with your service, nothing, they are not inconsistent. Take down.
But kindly, but page 32, Malad.
Take it to the issue as to whether a writ petition is maintainable. That the learned single judge has rightly addressed the issue and disposed of the writ petition with the observation that and dispose of the writ petition. By giving liberty to the writ petitioner, the enforcement of any contract, claim damages against the respondents in an appropriate civil or criminal forum, civil or other proceedings, if otherwise maintainable in law. If stated, the petitioner joined as an assistant teacher in the school on 6 November 2017. The petitioner thereafter joined the post of principal of the same school on 26 March 2019 and resigned therefrom on 26. It was accepted by the school on 2nd March. After the contention of the petitioner that after his resignation as principal, he continued to remain the post of assistant teacher. So stop. Rightly, the other single judge has rightly observed that that upon rightly observed upon noticing that the resignation from the post of assistant teacher and joining as a principal. Now, conclude. Now, the learned teacher, upon noticing the fact that he resigned from the post of assistant teacher and thereafter joined as a principal, would automatically mean that the petitioner was absorbed in the regular post of principal and was functioning as such. So, in fact, it would be a promotional post, not a resignation from the post of assistant teacher. After is received from the post of, after he has resigned from the post of principal, his earlier status as an assistant teacher cannot arise because of hierarchical uh, hierarchical status, hierarchical status uh, received by reason of his appointment as a principal of the school. Since it is not a case of termination, decision in Marwari Balika Vidyalaya Marwari Balika Vidyalaya versus Asha Srivastava, 14,000 bracket of 449 for that line. This would be clear from the observation made in the subsequent decision in St. Mary's Education Society and others versus Rajendra Prasad Bhargav and others. Reported in 2023 bracket of 4 SSC 498, paragraph 62. The school was receiving grant in aid in this case.
No, no.
Paragraph 63 and 64 of the same decision. 62 and 63 of the same decision, which is reproduced to this grant. Here of the opposite, the applicants are rejected. ওটা তো বলে দিলাম না না ওটা তো বলে দিলাম The letter of resignation is now the letter of resignation and acceptance by the school is kept to the record. By the secretary of the school is kept to the record. Next. Yes, next file, please.
Item number 8.
Yes.
Mr. Shomo Mojumdar has been briefed in this matter as a senior. He is not keeping well today, having a high fever. If my not come to court, he called me today in the morning that he's not having a high fever today. No, no, not after vacation. Any day. Didn't show seasonal.
Form of an affidavit. Today, only I have received the instructions from my client. Kindly, I am praying you also only 7 days time to prepare affidavit and to get it affirmed. Kindly accommodate me. Only 7 days, I am praying.
First of all, 13th will be directed.
Yes, my lord. I do admit.
September.
Yes.
Please for the state.
I am for the state.
You have filed your
I have nothing to say, my lord. All
On the prayer of Mr. Thomas appearing on behalf of NCT. That we file a report. Earlier,
বলা
directive
আছে।
extended by 1 week from the. The report shall be served upon the.
এর আগে কবে হয়েছিল?
One
দেখতে পারলাম। Grateful.
for 2 weeks for the. Next.
Weeks. করে দাও। এটা দিতে দিতে এইটা
Number 10.
My lord, in this matter, I am appearing for the appellant. There is a small typographical error in the order dated order dated 36/2023 of Honorable Justice Subroto Talukdar.
No, your final application.
Application for correction.
Correction. But since one of the judges is available, it has to go to that bench. Put the way also.
In paragraph 3, instead of technical stuff, it will be assistant professor.
Yes, you agree.
Lordship, I'm appearing for the private respondents number 4 and 5.
But agree to this.
Lordship, I'm agreeable to it. This is a type description, Lordship.
No, but you are
Can be correct.
By consent of the parties, this application is taken up for consideration. It's an application for correction of the order. Exactly. In paragraph 3, the legislature was described as a technical staff.
Of the appellant led by Mr. Kishore Malad, follows Bose my lord.
11, there are two appeals arising out of same order. 11, my learned friend is the appellant, I am the respondent. And 12, I have filed an appeal.
My lord, first of all, my humble submission, my lord, the order passed by the my lord, the honorable single judge, my lord, without determination. Yes, my lord. My lord, the kindly see the writ petitioner prayer. The main whole issue against the two, my lord, the employees, the employees, my lord, the organizations. There is no the connection in respect of education. My lord, kindly see the determination group 2.
The two unions.
Between two unions, my lord, I
Yes.
tell your lordships, that my lord, my union is West Bengal Board of Secondary Education Employees Union and their education is Paschim Bongo Madhya Shiksha Porshod Kormachari Union. Both the unions, they have been, my lord, allocated, my lord, a party.
Group 9, my lord.
Send back to the group 9.
Group 9.
Have you filed it as a classified as group 9?
My lord.
My lord, only.
No, no, my lord, I am not the read petitioner. Read petitioner is there.
Only one thing I'll be indicating to
Yes, my lord, that
my
is
lord,
my main ground.
that
That is my
he
main.
has taken a point of jurisdiction.
Yes.
That, my lord, the learned single judge who passed this order had no jurisdiction. Now, my lord, I have checked up, my lord, the jurisdiction which was given to the learned single judge, subject to correction of my lord's, my lord, I told my learned junior to bring the list. He, my lord, did not, my lord, bring the list. I wanted to show before my lords that, my lord, there was police inaction. Now,
No.
action.
Group 2.
Not police action.
My lord, kindly see the read petition first, my lord, the classification list read petition, my lord. My lord, kindly see my read petition. My lord, they have. Yes, group 9. My lord, kindly see page 17. Page 17, my lord. They have, my lord, indicated that it is group 2. My lord, he, my lord, the read petition of
I
the
appear on behalf of,
second appeal, my lord, Mr. My senior, my lord.
I have, my lord, filed a writ petition. My lord, only one thing may I submit to my lords.
By the
My lord, 1405, page 17, the classification under group 2. And my lord, the prayer of the read petition is different. That is in under group 9.
Now, what my lord, kindly see one thing, my lord, I just.
And the, my lord, the as per my lord, the appellate side rules and the classification. Yes, monthly list. Just some दिन.
it should be a group 9.
Yes, my lord, purely group 9. This out.
Now, my lord, I say, my lord, if a judge does not have a jurisdiction, I cannot say that, my lord, but your lordship, my lord, only one thing your lordship may kindly consider for a second. Now, my lord, the West Bengal Board of Secondary Education, they themselves.
Find out the principal really.
My lord?
You have to find out the principal really.
No, I submit to my lords, my lord, your lordship may kindly consider the prayers. Your lordship had, yes, your lordship may kindly consider the prayers. My lord, for a second, my lord, I just.
Consider the prayers. You have considered. It has nothing to do with the education.
Yes.
5 and 6 to assist. 5 and 6 are police
Because of the fact
authorities.
that the release
Eleven and 12.
Yes. 11 my lord, my senior learned is appeal. 11 টা 2 Oh, 11 he is appearing, I am appearing. তাহলে এটা একটু দিন আমাকে, একটু দিন ওটা একটু কারেকশন করবি।
First you establish.
11 আমি তো, আপনি তো 12 নাকি? আপনি তো 12
আমি 12
ঠিকই তো আছে।
11 এ আমরা
Item number 13.
I'll run for the appellant in this matter.
will be appellate দিচ্ছি না।
My lord, on the last occasion, 15th of May, the Honorable Division Bench was pleased to formulate the points and direct the Commissioner to come with a report. If your lordship kindly takes 15th May order, the last order. Dr. Patro was present.
Patro, lords, Dr. Patro is appearing for the commission, lords.
He was present. But kindly take the 15th May order for once. And the matter has already been decided by your lordship, 2 points. If your lordship kindly takes the 15th May.
Yes, Mr. Patro.
My lord, the copy of the report has been handed over to me, one copy, today morning itself, and it goes in my favor. May I just hand over, my lord? 2 points, single teacher, and whether
দেখি তুই অর্ডারটা দেখে নে
কোনটা রিপোর্টটা আমি দিয়ে দিচ্ছি আচ্ছা রিপোর্টটা
আর নেই তো
লাস্ট পেজ মাই লর্ড দি অ্যানেক্সচার
আমাকে দেন একটা
একটা কি ওনারা দিয়েছেন আমাকে মানে কি যদি So, my lord, basically 2 points. Yes. My lord, on two grounds, my lord, that is the single teacher and the below 5 years. In two, my lord, you have lordships has already considered past Prapti's orders and Shubhadeep Ghai's order. Your lordship had already passed this order that below 5 years and single teacher will not be a ground. One. Now, secondly, what happened exactly? The petitioner was a teacher of a school where there was no student at all. There was a zero enrollment. Now, my lord, he was posted to a nearby school temporarily, keeping the parent school as his principal place of.
So your case should be considered on the basis of.
Jogendro.
Jogendro.
Yes. So, Jogendro, I have spent 13 years. So the 5 years embargo does not arise.
Well, Dr. Patra is coming, Lords.
But only one thing.
Here, Lords,
Only
that
one thing.
service condition,
Only.
Lords, the 2 years or 2 years
No,
they
no, no.
completed, Lords.
Yes, 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 5 years.
5 years.
Yes, yes. My lord, only one thing, my lord, it is to be channelized through the DI because now since the online portal is closed, we
The appellant is approved by the
But only one thing, may I just
এখনো দেয়নি। বসেই নি এখনো।
Supplementary list, application
kept
item
this
number
matter-
1.
We kept this matter for two things. One is that you have shown us yesterday the rules. Can you please find out the rule from which volume it will be there? One
Volume
of-
1, your lordship, school education manual, volume 1. That's I do.
Education manual, the education manual.
Education manual.
Education manual to the volume 1.
Education manual.
Education, eight. দাও, বইটা দাও। ওনাকে দাও। আমারটা আছে এখানে, আমার ফাইলটা এখানে আছে। We want to know two things from you.
Lordship.
You said that the earlier management rules, that is 28(8) is no more there.
No.
Then what would happen when a disciplinary proceeding was continuing and in the meantime, it is not concluded before the retirement? Then what is the procedure? What is to be followed? Is one aspect. If the answer is that, well, disciplinary proceeding cannot proceed, then he gets retired. So disciplinary proceeding gets stopped and he's entitled to all consequential benefits. But if it says that it can be continued irrespective of this retirement, if the rule prescribed for that, or any other rule prescribed for that, where determination of that issue is required for release of any pensionary benefits. For example, there are certain rules which are gratuity. Say pension may not be provident fund pension. So if it is pending, it will not be released. That means there's a deemed continuation of the rules.
Lordship. To that effect, my submission would be, lordship, in other proceedings, lot of proceedings which was initiated, thereafter change in rule, and thereafter 2018. So they are continued in this. Though in the act, the new amendment rules or act, there is no such specification, but in those cases, we'll have to go by the General Causes Act. And I am also with the General Causes Act. It is very clear on this point. When a rule is repealed, what will happen to the continuation of the proceeding?
No, General Clauses Act may not apply because judgments are quite clear on this point. That if the extant rules does not permit you to proceed, then you have no right to proceed. The rule must provide for it. Because this is a complete cessation of employer-employee relationship.
No,
Unless the rule is
that has been complete seizure. No, my lord, my submission is that it was initiated, this proceeding was initiated when he was in service.
Correct.
The total proceeding was concluded and it has reached to a finality, whatever penalty has been
It
given.
was set aside.
That was set aside by the court on the ground, that was set aside by the court after the amendment. In 2000, amendment was in 2018 and the learned trial judge passed the order in sometimes in 2023. So after the amendment, it was set aside not on the merit, but only on the ground that there was some procedural technical latches. Thereafter, his lordship directed him to reply to that inquiry report.
But who will take a decision that body is defunct?
My lord, then
It's going to, because that body is no more there.
no more. Then your lordship, as per my understanding, the inquiry report is to be placed before the board, and now from board will initiate from the being the disciplinary, because what happened in that point of time, the managing committee was the appointing authority. That is the reason the managing committee was the disciplinary authority.
It was the 69 rules, no.
69 rules. Managing committee was the appointing authority and hence they were the disciplinary authority. Now after 2018, board became the appointing authority. Hence board became the disciplinary authority. So my lord, I'm asking a question to myself, my lord, if there is an allegation, whatever allegation, money defalcation or whatever there is, my lord, the proceeding initiated but not concluded. Let them assume it is not concluded. Now change in rule. What will happen, your lordship? My allegation goes, my crime goes. It will remain.
The law is well settled on this.
Yeah.
The law says that you cannot initiate or continue with the disciplinary proceeding after the retirement of.
No, my lord, I'll show. That is 2018 says something else, your lordship. Yes,
That's what you want to show.
yes.
Please show us.
On this subject, I have a judgment of our High Court. Can you see? 2017, same. 2017, Volume 4, Calcutta High Court Notes, page 382. That is yes. Supreme Court judgment. I give you the one Xerox copy also. That cross application of our now Justice Dotto appeared for the incumbent, my lord, the petitioner. Just a minute. 2007.
My lord.
Yes, well, this is the judge. Same set of facts.
My lord, এটা একটু দিয়ে দিন না। আমি এখানে এই করে দিচ্ছি।
নাম্বারটা কম।
My lord, this is the head. My lord, kindly come to Rule 5.
Rule 5.
Rule 5, it deals with the disciplinary proceeding. My lord, Rule 5(1) says that on receipt of any complaint, a preliminary investigation is to be held. My lord, I'm pointing, my lord, kindly come to Rule 5, Sub-Rule 3. Lordship got. Well, Rule 5, Sub-Rule 3, that provided, my lord, kindly come to that portion. Well, may I read? Provided that no disciplinary proceeding shall be initiated after 3 years from the date of alleged misconduct becomes known to the board. 1 point. However, the said period may be extended with the approval of the state government. Next, your lordship. Second, provided further that in case of retired teaching or non-teaching staff, disciplinary proceeding may, with the approval of the state government, be initiated within 3 years from the date of retirement if the misconduct becomes known to the board after retirement. So, my lord, even after retirement, within 3 years, if the misconduct comes within the knowledge of the board, then also disciplinary proceeding can be initiated. And in this case, it was within the knowledge of the board when he was in service. And board was proceeding, board granted approval. Maybe there was a technical latches. So it is well within the knowledge. So, my lord, even after retirement can be done.
The proceeding was under the old rules.
Old
Then
rules.
proceeding, it is not been directed to, it is old. That rules will apply.
So, this proviso says initiation of disciplinary proceedings. Now here, continuation of the disciplinary proceeding.
Yeah.
Now, is there any saving clause that all proceeding initiated under the old rules shall continue till the?
There is no saving clause. That is why, lordship, I am relying upon the General Clauses Act. My lord, may I read, my lord, may I read the clause? General Clauses Act. My lord, 6, section 6. My lord, may I read? Effect of repeal. May I? Effect of repeal. General Clauses Act, your lordship. Where this act or any central act or regulation made after the commencement of this act repeals any enactment hit thereto made or hereafter to be made, then unless a different intention appears, the repeal shall not, now my lord, shall not affect the clause, subclause B, affect the previous operation of any enactment so repealed or anything duly done or suffered thereunder, or shall repeal shall not affect any right, privilege, obligation, or liability acquired, accrued, or incurred under any enactment so repealed. Next, my lord, shall not affect any penalty, forfeiture, or punishment incurred in respect of any offense committed against any enactment so repealed, or affect any investigation, legal proceeding, or remedy in respect of any such right, privilege, obligation, liability, penalty, or punishment as aforesaid. And any such investigation, legal proceeding, or remedy may be instituted, continued, or enforced, and any such penalty, forfeiture, or punishment may be imposed as if the repealing act or regulation had not been passed.
But what to say to this division main judgment?
Lordship,
This division main judgment? No, no.
Yes, I'm giving just go.
No, you just give the.
Oh, yes.
same.
Just.
2005, 2005
Yeah.
না না ওটা একই কি জাজমেন্টটা
2007, volume 4, CH.
হ্যাঁ আপনারটা আলাদা জজ, হ্যাঁ এটা একই।
Thank you.
Well, here it says it cannot be continued, but this 2018 Act says it can be continued. Even it can be initiated. Continuation is separate. Here it can be initiated afresh. So, in this case also, as because it is within the knowledge and it has been initiated, it can be initiated afresh. Or that inquiry report from where the
If you initiate this process, that is up to you.
No.
But there cannot be any continuation. You see, there cannot be any
No,
continuation.
no.
Because
Then
if you are saying under 5, then no disciplinary proceeding shall be initiated. After 3 years from the date of alleged misconduct becomes known to the board. That period is over.
Here situation is different. Here,
No, we are on this situation.
yes, here is
So here you cannot initiate any proceeding now.
we are not trying to initiate also. We are not on a way to initiate also.
No, but
That is the same.
What
It is just
submission I made the other day, not on this. My submission
no,
was
he is challenging the order of the learned single judge.
that is of the managing committee.
Yes, so managing committee is no more there.
No more there.
So if the managing committee is no more there, then is there any power on the basis of which it can be continued?
Managing committee cannot continue.
Then who can continue?
It can only be done in such a way that the school authority that inspect the whatever report, investigation report, that if the school authority forward it to the board,
No,
and then
so
the board can continue.
No, so the directions passed by the learned single judge that you supply and then that direction can go.
That will go.
But whether they can continue or not with or not, that is a matter, well,
It's to be decided because law is not clear on that point.
No.
Rules are not clear on that.
listen of this judgment. It
Says that cannot proceed, cannot be continued after retirement.
Yes. So now because by sending it back, it will amount to continuation of the disciplinary proceeding, which is not permissible unless there is a saving clause.
No saving clause, but only if there is in absence of saving clause, this Special Clauses Act can come into effect as if.
But here it was not held to be so.
But whether this has been dealt, this special clause, your lordship, this it has been dealt in that judgment, my lord. I have to go through the judgment, lordship. General clauses has been dealt in that or not, my lord. I have
No,
to
General
go through.
Clauses Act was not.
No.
So, my lord, this
There
cannot.
are also mentioned, there are 3 punishments: censure, reduction of payment, there is the person condition is retired. You cannot impose punishment 3 punishments also.
Yes, your lordship.
It has been special.
Lordship.
That was
In
hard.
absence of
He is no
saving
more in
clause,
service.
What will happen? General clauses says such. So, my lord,
He is saying today after you retire, you cannot give any punishment either way of removal
Yes.
or 3
he has retired. No more punishment.
That is discussed.
continuation for what? That is the point.
Right. Yes.
So the question is whether it can be continued or not. That is the reason.
It cannot be continued by the managing committee. Managing committee does not have any power to continue.
So the direction goes.
That direction goes. Managing committee cannot continue.
So we put a full stop there only.
Yes, it can be done.
Yes, sir.
But what my submission was before your lordship, that on that point, that where your lordship was on the last day, your lordship said that because the criminal proceeding.
No, criminal proceeding was
that only that point I was my submission.
no, criminal proceeding was only one of the issues.
Only of this. In that case also, brother, I refer to your lawsuit. Criminal case was pending. The lawsuit died, that will be
In that case,
decided.
I have some judgments in my hand. Wala, today I'm not with those.
কালকে গতকাল করে রাখবে হার্ডিং পার্ট আজকে by concept What is the old rule?
Old rules, but this is with me, but this is the old rule. That is reason to.
No, rule 28(8) of the this is the order you have challenged in the before the
To supply the inquiry report,
no. So
No,
they
no,
say
order of termination.
termination.
টার্মিনেশন হয়নি আপনাকে বলেছিল ফোর্সড রিটায়ারমেন্ট কি একটা বলেছিল না টার্মিনেশন অর্ডার অফ টার্মিনেশন
Termination.
no termination without giving you a opportunity of replying to it.
no no
No, 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 no.
Well,
That is only justified. Page 109. Page 109. Page 109. This is a
109.
letter. No, 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 no. But impugn order.
No, this is the letter of dismissal. Yes. কি বলেছি?
No, my lord. In particular, this case,
Yes.
in particular, this case, as because it was continuing, he was proceeding concluded, thereafter it is untouched, and he retired in 2014.
No, simple question is, could you have continued with the disciplinary proceeding of a person who has retired in the meantime? You cannot.
No, he retired afterwards.
No,
He
no.
retired afterwards.
No, no.
2014, I have retired.
আর কবে তোমাকে দিয়ে
No, he retired in 2014. Yes, he was dismissed.
terminated first in
No, no,
2013.
correct. But thing is this, when the court passes an order, then it revives the disciplinary proceeding.
No, that
For the-
cannot be revived.
No, that is why it revives the disciplinary proceeding. That is why we said, কি বললাম? বললাম?
No, I was thinking on other aspects because lot of matters, it will create difficulty in those.
For continuation of the disciplinary proceeding, that may have abated by reason of
Nothing is here against him.
we don't know, we don't know.
Yes, all right?
We just dispose of your writ petition, that's all.
Now, then, what happened? Because he has retired. There is no
You apply for your retirement benefits.
I shall apply
whatever.
for. But you give that direction also.
আগের দিন দিয়েছিলেন judge.
That direction is there.
All retirement benefits admissible to the writ petitioner may be released, subject to compliance of all formalities.
But within you lost yesterday 6 weeks you lost.
Subject to compliance of all formalities within 3 months from the date of within 3 months from 3 months from, sorry, within 3 months from the date of submission, all required papers. The school authorities are directed to comply with direction forthwith.
Okay.
Now, you are for the state, Rajoshi Basu is for the state. You are for the West Bengal.
Secondary, I'm for West
Modhu Jana, respond number 5 and 6, which respond number 5 and 6.
It's only a school authority. Today he is not here.
No, very well, but please inform them since the
Yeah,
matters
yes.
are there.
But shall I
Their
get
names
back
should
my,
also be recorded.
but shall I get back my books when I have hand over a Xerox copy?
Yes, yes. No, let the book be here because Xerox copy sometimes fits your difficulty. Please ask your junior to collect the book.
Yes, yes.
সবার নামই রেকর্ড করে দেবে কালকে হার্ডি বইটা না জাজমেন্টটা দিয়ে ছোট রেখে আদার ইস্যু তো পড়ার প্রয়োজন নেই sentence where moreover it appears that the writ petitioner was exonerated of the first charge forming the charge sheet by দেখে দাও আমার ড্রাফটটা দাও আমার ফাইলটা দাও CRA number 14 of 2011
Yes, yes.
on 6 March 2020.
Yes.
Bracketed Jitendranath Vishwas versus State of West Bengal.
Okay.
এগুলোকে না ছিঁড়ে ফেলে please inform them. Yesterday we are just making it part-heard, that's all, not important. Please inform the others that this is.
Yes,
being
I shall
part-heard.
inform others.
And their names are recorded.
Yes, yes. Okay.
চলো, নিয়ে নাও। Yes. এটা ওর বই
এখানে রেখে দিন আপনার কাছে
41.
Yes, sir, I'm appearing.
41.
I
And I am for the
I am
appointment.
on behalf of the university, my lord, my senior argue in V code, my lord.
I am praying leave to file affidavit.
There is a direction. UGC only clarify the environments, the environmental science and environmental arts, whether it is equivalent or not.
Studies or science.
The extreme case, my lord, two things are there.
দেখ না এটা দেখ সে কথা বলেন অ্যাপিলেন্ট আমি হচ্ছে অ্যাপিলেন্ট
So the university must decide the equivalency.
Prior to that, I have to say, as per, actually,
Just like it.
as per UGC notification, my lord. As per UGC notification 2014, that I have annexed page 10.
Yes. Yes.
There are several degrees specified by the UGC.
That's specific.
Specified by the UGC under section 22(3), subsection 3 of the Act, UGC Act, my lord. These degrees has not been reflected in the notification. I have annexed several degrees that has not been reflected in nomenclature of such degree in the UGC notification. Number one. And regarding equivalency, my lord, it is last page, my lord. Equivalency of degrees, diploma and certificate ECG are not determined by the UGC.
It is by the university.
Yes, my lord. It is higher education equivalency decided by the university concerned.
Yes.
Actually request a visa because the degree actually earmarked by the UGC 1956 and onward. Therefore, environmental science in 2021, 2000, I did some time because this is quite confusing. I'm not at a glance. I was sent by my junior to that one. So I need some time because it's a very interesting thing whether, because in 2019, 21, UGC declared, issued notice that university environmental science has to be.
Mr. Mukherjee, what we propose to do? So we stand. We are not saying that for this year you change it, but if you have a, I think it's a you have a what you have a syndicate or what you have academic council.
Just 1 minute. Kindly give a short adjournment. Let me go through this UGC affidavit, and therefore let me go through the notification issued by the UGC regarding the environmental side. So that's why I'm telling, my lord. Otherwise, what happened? Because UGC has already issued a notification, and because and made it compulsory for studies in the higher the graduation and also post graduation. So I think, my lord, that's short time. I let me assist the court by producing those notification issued by the UGC. That
no. UGC said, in the affidavit he has said that MSc Master of Science, Master of Art are UGC specified level degrees. They are saying.
Yes, that is right.
Equivalence is for the university to decide. So they are not saying that equivalent or not, that is for the university, maybe the academic council to decide. So your academic council should decide that whether these could be treated as equivalent or not.
Yes,
that's the only thing.
Number one thing, because all the experts appointed by the UGC, they are expert on environmental science. They said this is same. But now, my lord, in view of the 2020 or 21 notification, whether it is coming within the sphere of the science or arts, that is the subject matter. So,
notification, which notification?
Because I have to submit before the lordship. There's a volume there. So kindly fix another date. I will try to assist this court, my lord.
The affidavit on behalf of University Grants Commission is taken on record.
The part difference.
Mr. Urunang Chakraborty, counsel for the university, has prayed for an adjournment in order to file an affidavit disclosing relevant documents. Stop. The matter is adjourned for 2 weeks.
Whether already there is, because of now it has the importance is that UGC environmental science become the curriculum of the undergraduate. So I think, my lord, the court should clarify whether this is same or that syndicate will or the court will decide. But point is whether
what we propose to do is this,
my lord.
We may not disturb this appointment.
Yes.
Because we may not disturb this because there are some which are overlapping.
Right.
But in future, the
Yes.
academic council or whoever is there,
Hmm.
they must take into consideration that how these subjects are treated by some renowned universities all over the world.
Yes, my lord.
A consistency is maintained
Yes, my lord.
and the candidate, because both are equally qualified. And
Yes,
there are subjects which may be equivalence, may have some relevance.
right. my lord.
So
Yes, my
we,
lord, right.
yes, so we'll not disturb this appointment. But in future, if
Future, my lord.
so,
Hmm.
you have to clarify that.
My, that is there, that will. Because otherwise, will what happen?
And
Govinda Bharat,
And if it is found that what she is saying to be correct, then our candidature may be considered as soon as any vacancy arises.
my lord.
That is what
Definitely.
we should do.
My lord, but point is, my lord, Rabindra Bharati is arts faculty. That is the problem. Because there is no science faculty in Rabindra Bharati University. That is why this nomenclature is MA. That is the problem. Because Rabindra Bharati is not.
Whatever is there, if you have, if there is a subject which also requires a scientific background,
Yes, my lord.
you have to find out which one is predominant. That is a
Yes.
test.
Right. That's
So if science is predominant, then it is a science chair. If it is arts is predominant, then becomes an arts chair.
That's
That's
clear, right. That's
My lord, next Monday, my lord. Next Monday,
2 weeks.
2 weeks. After 2 weeks. Probably it will.
Next.
Item number 42.
Yes, who is appearing in this matter? Yesterday also none appeared for the appellant.
There's a series of matters appearing
Yes, so
together.
we got confused, so we are not sure. Is this matters pending before the Supreme Court?
Yes, they are related to the Supreme Court matters. They are related to the matters which are
No,
pending.
but these are pending before the Supreme Court.
Yes.
So we adjourn it then.
Very
Although the appellant is not, that is why we did not dismiss this matter.
Yes.
So this issue is involved. Take down. Then please give the numbers so we can accordingly. The appellant is not, the appellant.
আমি 44 থেকে 55 আছি অ্যাপিলেন্ট
Appellant.
My lord, I am appellant for the item number 44 to 55, my lord.
Just a minute. Stand adjourned. The appellant, the applications. Stand adjourned. For 6 months. Now, stand adjourned.
Month list of November, your lordship, no, December.
Or else simply they can go out of the list. We limit it to
Difficulty is
mention-
this, go out of the list, once we do it, we lose track of the pending
Yes, that
matters.
is correct.
That's
Yes.
the problem.
On month list of December, your lordship.
For 6 months, with regard to mention in the event the special leave petition is disposed of in the meantime. 43,
Item 43.
same order. Then 44 to
44 to 55, my lord.
44 to 55,
I am for the appellant, my lord.
uni হচ্ছেন for the appellant. 44 to 55, uni appellant, same order.
Yes,
Same
sir.
order, শুধু
Sir.
appellant এর নামটা হবে, appellant appear করছে।
45 থেকে
44 থেকে 55 অবধি সেম
ওইদিকে আর তারপরে একসাথে
Yes, 56.
45
All
থেকে
56.
44 থেকে 50 একটা আচ্ছা
হ্যাঁ পুরো দিয়ে দিয়েছে আপনার
এবার 56 আইটেম নাম্বার 56
বুঝতে পারছি না।
কোনটা 56
এদিকে এসো, আমার পাশে এসো
এটা অমিতাভ বচ্চন
Yes,
56 হ্যাঁ না 44 থেকে 44 হ্যাঁ ওই দুটো আবার কি 59 কমবে কিছু হ্যাঁ লিবার্টি থাকছে তো লিবার্টি কথা তো থাকছে তো জানি না অনেকটা উল্টো আসে
One day accommodation.
I'm appearing on behalf of the school authorities, my lord. I'm submitting the opposition, affidavit in opposition, my lord. Kindly keep in there.
Important issue. Because room has been handed over, so what for you are fighting? You have handed over the room, nothing remains. Very good. The affidavit in opposition filed on behalf of respondent number 5 is taken on record.
আমি দিচ্ছি
Yes.
দিচ্ছি দাঁড়ানো আমি দিচ্ছি আমি দিয়ে দিচ্ছি একটা কপি মিসিং আছে
7.
57.
Lordship, I am for the appellant lordship. Kindly make it not this week, lordship. Affidavit in opposition had been handed over. Reply to be filed, lordship.
anyway for school
Which for your other side?
Bardwan University is the other side, lordship.
So Raghunath Chakraborty. So the principal appeared in person. Affidavit in opposition has been filed.
Opposition has been served upon me, lordship. The reply to be filed, lordship. Make it adjourned for this week.
But the
lordship.
affidavit in opposition is not on record.
No, that was served on me.
So service upon you will not do.
Yes, that to be filed
Take
at the
down.
time of hearing. And 61 same, lordship.
The university.
And 61 same.
56 and 61.
Yes.
Sorry, 57 and 61. Very well.
61 টা তাহলে বার করতে হবে
Yes, 58.
58
দেখি দাও। present করেছে। তারপরে
58.
yes yes
My lord, I'm the applicant. My
where is the certified copy?
the certified copy should be
Where is the
at
certified
the back of the memorandum of opinion. My lord,
No.
if- At this,
It was filed with an undertaking. Where is the certified copy?
my lord, that I have to
In
inquire.
all matters where urgency is taken,
My lord,
and on that basis appeal is filed, and thereafter we find that this matter is not listed, we'll dismiss it, recall our undertaking, and direct the appeal to be filed
if
with
it
a
has
certified copy.
not been filed, it will be filed
no.
as soon as
You
possible. My lord.
obtain, you showing urgency, you file it on 22nd March 2023.
It
And
should have,
thereafter
must
this,
have been
no,
obtained.
this matter was never been listed thereafter.
My lord, not.
So there was no urgency, is a pretension. We'll dismiss, list we'll dismiss all appeals
I will
which have been
kindly
filed with
give me
urgency
the
shown, but not with any
opportunity,
certified
my
copy.
lord.
So there is no urgency.
But will kindly not dismiss this. What has happened, my lord, after?
What has happened is happened because it is listed by us, not by you. Not at your instance.
But
not
the
mentioned by you.
problem is that
এবার
learned
থেকে না
trial court
কোনো-
has,
কোনো matter এ আমরা দেবো না। Don't একটা matter এও তোমার কোনো leave to file appeal দেবে না without certified copy। একটা matter এও দেবে না। সব urgency দেখায় তারপরে মার্চ মাসে
but
file
this
করেছে
was
urgency-
Bro Talukdar on a few occasions it could not be listed, my lord. But of course we should have filed our certified copy. It cannot be, there cannot be any excuse to that, my lord. It should have been filed, but
The
my lord
matter,
will,
full stop.
my lord will kindly give me one
matter
last
was-
opportunity to do
The
that.
matter was, the appeal was filed without certified copy showing urgency on 22nd March.
Will kindly not do that. Kindly not do that. I'm ready.
With the certified copy of the, with the certified.
My lord will kindly
the
not do
judgment
that, my lord.
And a revised report. Next matter, please.
My lord will kindly not,
Matter,
not.
please. Next matter, please. সব পড়া দাও তো আমি সবটাই করবো এবার।
My lord, I'm appearing on behalf of the appellant in this matter. My lord, from my lord's order, we had preferred an SLP and order of stay has been granted by the Honorable Supreme Court. And the matter is posted on 27th of September. Order. এই যে এটাও দিন এটা একটু দিন না
My lord, it is a similar matter like other matters, my lord.
My lord, in this matter, from my lord's order, we had gone up to the Supreme Court and a stay has been granted, my lord. I'm humbly praying if the matter could be stay out of the list, the liberty to mention.
Where's the order of this?
Yes, my lord. Okay.
Take down.
Page 9 and 10. And the matter is posted 27th of September.
We have passed any termination order. We have not passed any termination order.
No, my lord. My lord's order is dated 28th of March 2023. The stay was not granted, my lord.
Yes,
By-
it was not granted.
Had gone up on appeal from that order. We have filed an SLP from that order.
No, but this order has not been stayed.
Yes, my lord. Paragraph number 9 and 10, page number 9 of the order, Supreme Court's order. Several orders passed by the learned single judge and division bench.
So
My lord, by being aggrieved by the notification dated 1st of March and 13th of February 2023, we had preferred the writ petition.
this was passed in Gopinath Bhanjo's matter.
Yes, my lord. We had also preferred an SLP. Our SLP number is 7172 of 2023.
7172.
72. Internal page 3, last number is ours. I've given the status report also. 7172 of 2023. ma'am.
So that counsel, you are for the
Appellant, madam.
that counsel for the appellants has submitted that a special on 12th April 2023 that the termination orders already passed in the monthly combined list of January 2024.
Grateful, madam. Grateful.
Doctor is appearing for school service commission. ma'am.
Liberty to mention
I was appearing on this matter for
Yes, please.
placement the board as deliberated issue.
So this item number 59. Any other connected matter with this? No.
No, I'm not.
Madam,
Grateful,
these
madam.
Madam, these are all connected with item 42 to 55, my
No,
lord.
this is.
ও হয়ে
different.
গেছে ওটা হয়ে গেছে